Resuming debate, the Honourable St. Albert Edmonton.
Thank you, Madam Speaker. I rise once again to speak on Bill C-75. And let me say at the outset, as I've said before, one of the biggest problems with Bill C-75, legislation the objective of which is to reduce delay in Canada's courts, actually does really very little to reduce delay. And that, for a bill that is designed to reduce delay, the fact that it doesn't reduce delay is a pretty big problem, Madam Speaker. Let's talk, the Parliamentary Secretary to the Minister of Justice and other Liberal MPs who have spoken on this bill in this place have patted themselves on the back. They patted themselves on the back about as they have put it, the good work of the Justice Committee, which heard from 95 witnesses, as the Parliamentary Secretary to the Minister of Justice just stated, and that Liberal MPs listened to the key stakeholders, and they acted on the concerns raised by stakeholders. Let me say, Madam Speaker, that in the 3 years that I have been a member of Parliament, I have never seen a piece of legislation more widely criticized in virtually all aspects of this massive 300-page bill than Bill C-75. And despite the rhetoric from across the way about listening to key stakeholders, the reality is that on issue after issue after issue, the Liberals didn't listen. They ignored the concerns raised by key stakeholders at committee. Instead, they rammed the bill through committee, and other than a few minor changes, we are largely stuck with a very flawed bill, a bill that is problematic in so many different ways. Let me first, in that regard, highlight the issue of hybridization. Putting aside the issue of watering down serious indictable offenses, which is certainly a serious concern, from the standpoint of reducing delay, what hybridization is going to do is download even more cases onto provincial courts. 99.6% of criminal cases are already heard before provincial courts. And if any member questions my statement about the fact that this is going to result in the further downloading of cases, I say don't take my word, take the Canadian Bar Association's word. The Canadian Bar Association, in their brief to the Justice Committee, said, quote, hybridization would likely mean more cases will be heard in provincial court. This could result in further delays in those courts. No kidding, Madam Speaker. And yet, despite what the Canadian Bar Association said, this government says, no problem, we'll just download more cases onto provincial courts. Then there were public safety concerns raised about hybridization. One of the concerns that was raised was by John Muse, a former member of the Parole Board. He noted that among the offenses that are being reclassified include breaches of long-term supervision orders. Long-term supervision orders apply to the most dangerous sexual predators in our society. We are talking, Madam Speaker, about individuals who are so dangerous that after they complete their sentence, they are subject to a long-term supervision order for up to 10 years with many stringent conditions. And John Muse, again a former member of a parole board, said this is a serious problem to treat breaches of these orders which are imposed on the most dangerous of people, and that they should remain solely indictable, mainly because a breach of a long-term supervision order is a sign that these very, very dangerous offenders are returning to their cycle of violence and exploitation of vulnerable persons. We're not talking about marginalized people here, as the Honourable Parliamentary Secretary referred to with respect to minor administration of justice offences, breaches of orders, which should be treated seriously, but we're in this case talking about the most serious offenders. And instead of heeding the advice of John Muse, the government said, no problem, we'll move ahead, forgetting about what a member of the National Parole Board said. Mr. Muse, as well as Sergeant Chow from the North Vancouver Police Department, who is the Deputy Chief Constable of the Vancouver Police Department, he appeared before our committee, and he said that there's another problem by reclassifying what are some very serious indictable offenses, and that is as it relates to taking a sample and putting it into a DNA database, the national DNA database. Right now, if someone is convicted for one of those offenses as an indictable offense, the Crown could apply to a judge to take a DNA sample to be put into the national DNA databank. However, with Bill C-75, if the offense was prosecuted by way of summary conviction and the individual was convicted, therefore, of a summary conviction offense rather than an indictable offense, no such application could be made. And to talk about the impact that that might have upon police investigations, Detective Chow noted in his testimony that of the 52 offenses, or of the 85 offenses, rather, that are being reclassified, that as a result of DNA samples being taken, over the last number of years, 19 homicides and 24 sexual assaults were solved. But instead of listening to Chow, instead of listening to Muse, the government said, we don't care, we're moving ahead. Mr. Speaker, then there is the issue of inquiries, whereby if the maximum sentence is life, a preliminary inquiry could be held. However, for all other offenses with a lesser maximum penalty, a preliminary inquiry would no longer be available. The government claims that this will help speed up the court process. But, Madam Speaker, witness after witness begged to differ with the government. Let me quote again the Canadian Bar Association in their brief, what they submitted to the committee on limiting preliminary inquiries. The Canadian Bar Association stated, quote, this would not reduce court delays and would negatively impact the criminal justice system as a whole. Any connection between court delays and the preliminary hearing is speculative at best. If you don't want, Madam Speaker, to take the word of the Canadian Bar Association, perhaps you might be interested in taking the word of the Bar du Quebec, which stated that, quote, the Bar du Quebec opposes this amendment. By limiting the use of preliminary inquiries, some argue that we can speed up the judicial process and thus reduce delays. We believe that limiting preliminary inquiries in this way would be ineffective or even counterproductive. Then there was Philip Starr, a criminal defense lawyer from Nova Scotia, who said before the committee in respect of preliminary inquiries, quote, they're incredibly helpful not only to the accused, but to the Crown and ultimately to our system by cutting down on delays, unquote. So much for the government's assertion that limiting preliminary inquiries is somehow going to reduce delays. But it gets better, Madam Speaker, because Laura Lee Dale, another lawyer, a defense counsel who appeared before the committee, said before our committee, quote, two major studies have concluded that preliminary inquiries do not contribute substantially to the problem of court delay. Preliminary hearings facilitate the resolution of potentially lengthy and expensive trials in Superior Court. They are often used instead of, rather than in addition to, trials. They expedite the administration of justice. It is far easier and quicker to get a 2 to 4 day prelim as opposed to a 1 to 2 week trial in Superior Court. And then there's Michael Spratt, who said there is a delay problem in our courts, but preliminary inquiries are not cause of that delay. Madam Speaker, witness after witness, as I said, told the government that this is not going to work. It's not going to reduce delay. But did the government listen? Did the Liberal members on the Justice Committee listen? Apparently not, Madam Speaker. And, further testimony on prelims was from Sarah Lehman, who said, quote, 87% of them actually are resolved. Cases are resolved after the preliminary inquiry process. It saves the complainant, in the context of a sexual assault complainant, in the vast majority of circumstances from having to testify again and from being re-traumatized. And so, again, Madam Speaker, while the Liberal members opposite say we listened, the evidence before the committee and the response of the government to the evidence before the committee demonstrates exactly the opposite. And, Madam Speaker, even if one accepts the reasoning of the government, despite all of the evidence before the committee, that limiting preliminary inquiries will in fact reduce delay, it is important to note that preliminary inquiries only take up about 3% of court time across Canada. So, Madam Speaker, to the degree that this is going to have a beneficial impact, the fact remains that it is a very small piece of the much larger problem of backlog and delay in Canada's courts. Madam Speaker, let's look at the issue of judicial referral hearings and the evidence that was before the Committee on Judicial Referral Hearings. Serious concerns were raised, including by John Muse, a former member of the National Parole Board, as well as from Mr. Chow from the North Vancouver Police, about the fact that individuals who commit an administration of justice offense who are referred to a judicial referral hearing would not have that breach of an order or other administration of justice offense entered into CPIC. Right now, if someone does commit an AOJ offense, it's entered into CPIC, but thanks to this government's judicial referral hearing process, that wouldn't happen. Madam Speaker, as I mentioned when I posed a question to the Honourable Parliamentary Secretary, the consequences of not presenting the full CPIC record before a judge or justice of the peace can have devastating consequences, as my community learned and when Constable David Wynne was shot and killed by someone who had an extensive criminal record, including an extensive record of administration of justice offenses. Now what the government is doing is saying that the court wouldn't even have the benefit, if that CPIC record was to be presented, of the totality of that offender's record, criminal record, because after all, those breaches, those offenses wouldn't be entered into CPIC. And when I asked the Parliamentary Secretary, Madam Speaker, what the government intended to do to fix this serious public safety issue, which was brought up more than once before the Justice Committee, he regretfully didn't have an answer. The government has, and I should note, again, that in terms of judicial referral hearings, while they will have an impact on undermining public safety because that information of those breaches will not be entered into CPIC, the impact of administration of justice offenses on the backlog in our system is actually quite limited. And that, Madam Speaker, is because AOJ offenses are typically dealt with as tag-along offenses. What I mean by that, Madam Speaker, is that they're usually dealt with at the same time that the main or underlying charge is dealt with. So in terms of the amount of court time and court resources that are being used for the purpose of dealing with administration of justice offenses, it in fact is quite minimal. And again, Madam Speaker, don't take my word for it. Take the word of Rick Woodburn, the president of the Canadian Association of Crown Counsel. Here's what Mr. Woodburn said to the Justice Committee. I quote, "I can tell you from the ground that they don't clog up the system. They don't take that much time. A breach of a court order takes very little time to prove, even if it goes to trial, and that's rare. Keep that in the back of your mind." Did the Liberals keep that in the back of their minds? Apparently not, because they just went ahead with moving forward with the judicial referral hearing process without a plan, without any thought of the serious public safety issues that were raised before the Justice Committee. Then there's the issue of peremptory challenges, Madam Speaker. The peremptory challenges have nothing to do with delay, but they were added to this bill. The basis upon which the government has decided to eliminate peremptory challenges is on the basis that somehow it will increase the representativeness of juries, evidence that I've now run out of time to quote. Witness after witness after witness said quite the opposite, Madam Speaker, but instead of listening to those witnesses, the government just moved ahead. So, taken together, the record is very clear. 95 witnesses came to committee and gave evidence, and on issue after issue after issue, the Liberals ignored the evidence, the Liberals ignored the witnesses, and as a result, we have a very, very flawed bill that isn't going to get to the heart of the problem, and that is to reduce delay and backlog in Canada's courts. Thank you, Mr. Speaker.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Justice and Attorney General.
So I thank the member opposite for his contribution to today's debate and again for his contributions at the Justice Committee. To make the assertion which was just made that somehow this government is not listening to, attentive to, or indeed hearing and validating the work that is being done in committee is just patently false, Madam Speaker. 50 amendments were accepted at committee with respect to this bill, some of which came from the member opposite himself and his party. They included 4 key areas that related to routine police evidence, the use of legal agents, the aspects that related to the hybridization of terrorism and genocide that I outlined in my speech, which were proposed by the Conservative Party of Canada, and finally the bawdy house and vagrancy provisions, which were also addressed at committee and accepted at committee. So to assert in this chamber that somehow the committee's work was not validated is simply incorrect. What I would ask the member opposite in terms of my question is with respect to those important changes with respect to the bawdy house and vagrancy provisions, because more than that, there was a key provision about Section 159 of the Criminal Code that's contained within Bill C-75, and it's the repeal of 159. And to simplify matters for people that are watching, 159 said that basically consensual sexual activity amongst a gay young couple is illegal, whereas amongst a heterosexual young couple, it's perfectly legal. By removing 159, we're creating an equality for gay couples around this country who are young persons in Canada. Does the member opposite agree with this kind of change being commensurate with the approach that is necessary in 2018 to addressing LGBTQ discrimination in Canada?
The honourable member for St. Albert Edmonton.
Thank you, Madam Speaker. And in response to the question posed by the parliamentary secretary, let me say that Section 159 is an unconstitutional and inoperative section of the Criminal Code. In other words, it is one of these zombie laws. And I fully support the removal of zombie laws, including Section 159. But I'm surprised that the honourable member would pat the government on the back for taking this step, given the government's record of dragging its feet. It was all the way back in the fall of 2016 that the government introduced Bill C-28 to remove Section 159 of the Criminal Code. What happened to Bill C-28, Madam Speaker? 2 years later, it stuck at first reading. They could have passed that bill with unanimous consent, but because of the inaction of this government, Section 159 remains in the Criminal Code. To highlight the incompetence of this government, after introducing Bill C-28, in March of 2017, they introduced Bill C-39. Bill C-39 also would have removed Section 159 and other zombie sections of the Criminal Code. What happened to Bill C-39? It stuck at first reading. So, quite frankly, Madam Speaker, the only thing keeping Section 159 from being removed from the Criminal Code is this government.
And comments, the honourable member for Cowichan, Malahat, Langford.
Thank you, Madam Speaker, and thanks to the member for St. Albert Edmonton. He and I sat on the Justice Committee last year, and I certainly appreciated the subject matter that we dealt with. It's a committee that demands a lot of responsibility from its members, a lot of maturity, because the subject matter is also always very weighty. And I think that when we're deliberating on legislation with the Criminal Code, there's a real sense that the actions we take when we amend that statute are going to have real life consequences for people. And, you know, and he's right. He's right when he talks about this government's slow legislative agenda. I'll just correct him. It was C-28 was actually the victim surcharge, but it was residing at first reading. C-32 was residing at first reading. Then we had C-38 and then C-39. So, you know, the Canadian public got the feeling that the Minister of Justice, despite coming to power with a bold agenda to reform our criminal laws, was just kind of stringing the public along and giving us little crumbs, saying, yes, we're going to fix this, we're going to fix this. And then finally having C-75, which I liken to a giant amoeba, having swallowed all those previous bills, but adding a whole bunch more. And then now we're finally getting to the stage 3 years later where we get to give these a debate. And some of these, I agree with them, could have been passed really quickly, like the zombie provisions of the criminal code. Scholars and professors have been calling for decades to get the criminal code cleaned up, and we could have passed that bill very quickly, but we're only dealing with it now. So I would like to ask the member, would he not agree that, you know, when you're looking at sections like Section 287, which deals with abortion, Section 159, those could have been dealt with very quickly by this House, and it's a real shame that we're only doing that just now.
The honourable member for St. Albert Edmonton.
I would agree, Madam Speaker, that the criminal code should accurately reflect the law in Canada, and as a result, inoperative sections of the criminal code should be removed. And the consequences of not doing that can be very, very serious. And we saw that in the case of the conviction of Travis Vader in respect of 2 second-degree murder convictions overturned because the trial judge applied an inoperative section, Section 230 of the Criminal Code, which was struck down in the Martineau decision all the way back in September of 1990 when I was just starting in grade 1, and yet almost 3 decades later, it's there in the Criminal Code. The McCann family pleaded with this government to move forward. I stood with them. They're from my community of St. Albert. They cannot believe that almost 2 years later, C-39 is stuck, at first reading, which would have removed Section 230, which would remove Section 159, and here we are, all because this government simply can't get it done.
Questions and comments? The honourable member for Provencher.
Thank you, Madam Speaker, and I want to thank my honourable colleague from St. Albert Edmonton for the fine work he does on the Justice Committee and also for serving as the Deputy Shadow Minister for Justice. The intent of this bill, C-75, as indicated, is to streamline our justice system, but I'm wondering if the member could comment on this government's inability or unwillingness to fill judicial vacancies, how that impacts the streamlining and efficiency of our justice system.
Honourable member for St. Albert Edmonton.
Well, Madam Speaker, on the issue of judicial vacancies, I feel like a broken record. I wish I could stop talking about it because I would have thought that after 2 years this government would actually have done something about filling judicial vacancies. But they haven't done it. Filling judicial vacancies is the easiest and most straightforward thing to do in terms of a backlog in our courts. It's not the be-all and end-all. It's not going to solve all of the problems, but it's certainly a starting point. And with respect to this government's record, they can cite all the number of appointments that they've made after, frankly, letting judicial vacancies reach record levels. But when it comes to filling them, they established 14 new spots in Alberta. They provided the funding to fill those new judicial spots, and a year and a half later, Madam Speaker, 7 out of the 14 remain vacant. That is simply unacceptable. That is the record of a government that doesn't take filling judicial vacancies seriously.
Time for a brief question. The Honourable Parliamentary Secretary of the Government to the Minister of Justice.
So just very briefly, in terms of the competence of the government, I would point to the medical assistance in dying, Bill C-45, Bill C-46, and appointing 240 judges. But to get to the question, Madam Speaker, what I would point to is that the member opposite took issue with peremptory challenges. The question I would put to him is that, first of all, we haven't just eliminated peremptory challenges, we're allowing judges to ensure that any jury is diverse and represents the community that it serves, and we are emphasizing challenges for cause. Does the member opposite believe, as in England, as was done 30 years ago, that it is important that if one seeks to stand aside a juror, that you have a reason other than simply just the way that juror looks, and that you can motivate that reason in front of an impartial adjudicator?
A brief answer from the member for St. Albert Edmonton.
Speaker, I would cite the Canadian Bar Association, which said that in the case of peremptory challenges, that, quote, more frequently they're used to the benefit of Indigenous and other racialized persons, unquote. And the Canadian Bar Association goes on to say that, quote, abolishing peremptory challenges seem insufficiently considered. If legislative reform is required, it should be based on empirical data generated through an examination of the jury system, unquote. And indeed, that was before the committee. There was a lot of evidence about how it is actually going to make it less likely that juries are representative. One of the proposals was perhaps a consideration.
I'm sorry, I did.